Welcome to California Conversations. I'm Chuck Dick, a co-chair of the Cal-Arb Programming Committee, and I have the delight really today to spend some time with you interviewing one of our members, Patrick Byrne. Patrick's maybe a particularly appropriate person for us to include in this California Conversations program. He is indeed a native of California, educated in California, but I'm speaking to him today in Madrid, Spain, where Patrick is practicing with an international arbitration firm. And we're delighted to have you with us this morning, Patrick, to tell us a little bit about your story. And particularly, I'm sure people will be curious to learn how you found your way to Spain. But first, let's talk a little bit about Fresno. That's your roots. And how did you work your way through education to become a lawyer?
Yeah, so born and raised in Fresno. Had a great upbringing there, great city. So I went to high school there. Ended up going to UC San Diego for my undergrad, which were 4 absolutely amazing years. Was lucky enough to make it back there recently on a trip back home, and was quite impressed with some of the new buildings that they have there. It's quite amazing. So at UCSD, studied political science, already kind of got into law, took kind of every pre-law type of class they had to offer. Found that was the most interesting subject for me by far. So I kind of had law school in mind for quite a while. Ended up going to UC Hastings for law school in San Francisco. Had a great time there. And during my time there early on, I'd already kind of decided that my plan was to move back to Fresno, settle down, work there, raise a family, and then that was it. Similar to what my dad actually did. My dad was a UC Hastings alum, moved to Fresno, started a family, hence my upbringing. And so that was kind of my plan. It seemed to work well, and so I thought I'd kind of follow that path. Went back to Fresno, started my practice. Things were going well. Certain personal circumstances then took me back to San Diego, which there are worse places to return to. Started working there for a bit. And so that's kind of the start of my US time. I don't know if you want me to already get into how I came all the way out here.
Well, indeed, that's where I'm headed with all of this. But it's not every California lawyer who decides suddenly to pick up stakes and move to a different part of the world, let alone to Europe. You must have been a Spanish speaker. That's what attracted you to Spain.
Yeah, so I did not speak a word of Spanish at the time. And so my early careers, I started as a litigator, traditional litigator, a lot of labor and employment litigation, sub-biz litigation. But no, there was a point where some personal circumstances, personal relationships brought Spain into play as a possible destination. And no, I did not speak a single word of Spanish at the time. So needless to say, when my thought was dropping everything I had in California and moving abroad with the goal of working in international arbitration in Spain, there were some doubters. And you know, everyone that expressed doubt with this plan, I never fired back at them. It seemed completely legitimate to doubt what I was trying to do. And it has worked out so far, and it's been great.
Well, I think if I'd have been your father, even as a father lawyer, I would have been one of those doubters. But you overcame all of that, and tell us a little bit how you ended up migrating to the firm with which you're currently practicing.
Yeah, so at the time, like I said, I was practicing in California, labor and employment litigation with Fisher and Phillips. It was a great position, life was great. But as I mentioned, there were certain personal relationships at the time which suggested a move may make sense. And so I looked into how best to make that happen. As already a litigator with a dispute resolution background, international arbitration seemed like quite a natural next step. So I started reaching out to colleagues I had. My older brother is also an attorney, although not a disputes lawyer. He started reaching out to colleagues he had, and the question to everyone was, look, here's my background. I ideally would not like to waste, everything I've done. International arbitration seems, like a great idea. How best to make this happen, if it's at all realistic? And I was pleased that everyone seemed to have the same advice, because if the advice had been all over the place, I probably would have been completely lost. But everyone suggested, if you want to do this, go go to Queen Mary and complete this specific LLM program focused on international arbitration and go from there. By no means is it a guarantee you're going to get a job, but that is the best path. And so I actually reached out to several big names in the arbitration community, which at the time actually meant nothing to me. I just found them online, and now years later, I've worked with a lot of them or had them as arbitrators, and so now I realize the big names that I had randomly emailed, just saying, hey, look, here's my background. This is kind of my goal. I've been told, the Queen Mary program is the way to go. What do you think? And I was quite pleased that even a lot of these busy, big names in the field responded quite quickly with lengthy kind of responses that really show that they put some thought into it, and all kind of suggested, look, nothing's better than experience. Obviously, if you could get some kind of job in arbitration or internship, that's perhaps the best way to go, but that's easier said than done without any international arbitration background. And so, yeah, the Queen Mary program is great. It's well known. You'll learn some things. You'll make some connections. So I ended up going, and we can talk more about that experience. But in the end, I was lucky enough that while I was there, an opening at my current firm came about, and the specific opening was for a native English speaker, no Spanish necessary, for a prominent arbitration firm in Madrid. And so it was clear that this was where I was supposed to be.
I really do want to follow up on your practice in Madrid, but your discussion about Queen Mary and a smile on your face when you recall that experience suggests that there have to be some aspects of Queen Mary that you could share with us that would be particularly full of insight. And for somebody who is interested in pursuing the same course, perhaps something that you could share about Queen Mary that would be useful.
Absolutely. I mean, the Queen Mary program I would not be where I am now with this position if it weren't for Queen Mary for a number of reasons. I would say the Queen Mary program is great for a couple main reasons. One, just the quality of the education itself. The full-time professors there we had were fantastic at big names in the field. We also had guest speakers consistently from big names in the field who were always quite available for one-on-one talks. And so it was great to kind of learn the basics. Obviously, international arbitration is kind of unique as a field in that it's obviously a process. It's not learning all the ins and outs of international energy, although energy was part of the discussion, or learning just specifically private funds or something like that. It's a process. So we studied the kind of main arbitration rules and arbitration laws of a lot of your main seats, whether it be London or Paris or Geneva, Hong Kong, etc. And so learning how a lot of the places in which you're probably going to find yourself at some point as an international arbitration practitioner was quite useful. So just from the kind of academic perspective, it was great. The classes were interesting. We had a lot of participation, so it was a nice academic experience. But then on top of that, I think what was unique, especially as someone who had just been born and raised in California, went to school in California, worked in California. Granted, California is diverse, but in this program, I think within my specialty, I want to say there were about 85 or so students that I think came from over 50 countries, and not just as their general family background, but actually physically came from different countries for this program. And so it was great within this field to have such a diverse set of views. Often they would be able to give their experience doing either arbitration or certain aspects of litigation instead of arbitration within their given countries. And so you really gain a perspective on how different countries work, different mindsets to different legal concepts, and how perhaps a mixture of litigation and arbitration work in different jurisdictions. And so having that throughout the year, those different perspectives, and then still being in touch with those people now, it created a great network to start with. And I've had friends that I still talk to now, lifelong friends, and perhaps colleagues on cases in the future. And so it was just a perfect combo of academic setting plus the students themselves and the diverse backgrounds they had that created just a magnificent year. It was fantastic.
Patrick, I've heard it said you, in the practice of law, you just can't have too many friends. And your comment about the diversity of the student body at Queen Mary caused that to come back to my mind. Could you amplify a little bit on how your contacts with these people who are now presumably back home around the world have already become valuable to you in your international arbitration practice.
Oh, absolutely. And I agree. And I tried to do that when I was originally just a litigator in California and tried to kind of expand within California. Now it's a completely different ballgame. And so, yeah, now I have contacts in several countries in the Middle East, in East Asia, and Africa, and Latin America. And we stay in touch, whether it's LinkedIn or email. Sometimes it's shooting out questions of how local rules would work if we have a particular case that involves, that's maybe an arbitration, but involves certain aspects of minor little court things. Sometimes there are referrals of, hey, my client is doing something in X country, not necessarily Spain, but something you may know of, or the US. Can you do this, or do you know of someone else who can do this? There have been times where I've had discussions with former classmates about different arbitrators to choose, experience we've had with certain arbitrators, sometimes whether we are ourselves available as arbitrators for certain cases. And so I felt like I hit the ground running within the arbitration field, in that I immediately had this widespread network available to me, which, having since tried to expand my network in the 6 years I've been here, which I have to a certain extent, I realized how lucky I was to start with such a large group as I did leaving Queen Mary. It was certainly an advantage to the program, certainly.
Well, another thing that caught my attention, Patrick Byrne is not a Spanish-sounding name. It strikes me that there's got to be some Irish in your background. Tell me a little bit about how an Irishman such as yourself from Fresno ends up in Madrid.
Yeah, and so the Irish aspect has definitely played a part in all of this. So I had never been to Europe until my third year of law school in 2010. I had never stepped foot in Europe. I remember when certain classmates, my first year at Hastings, would talk about wanting to do international law and international this and that. To me, it all sounded like nonsense. I had no concept kind of doing anything outside of California's big, but my little California world. And so fast forward to 2000, I think it was around 9, my brother was having a conversation with someone who mentioned something along the lines of, oh, and because my grandfather was from Ireland, I'm an Irish citizen, as you know, and therefore, blah, blah, blah. So my brother stopped and said, excuse me? Just because your grandfather was from Ireland, you have Irish citizenship? I said, yeah. So my brother looked into it, and lo and behold, the way Ireland works is that if you are born to parents who were born in Ireland, you are a citizen at birth, which was my dad, born in San Francisco. And if you're born to a citizen who was not born in Ireland, which was me, because my dad was born in San Francisco, you just had to fill out some paperwork. So I became an Irish citizen in 2010, which was right before I studied briefly in Leiden University. So that was the first time I got to use it. And at that point, it was just for fun. I got to use the EU line at the airport, skip ahead of everyone, which wasn't that useful at the time because I still had to wait for my American friends to go through the long foreign line. But it just seemed like something fun. But then when the time came up to possibly move to Europe, and not just move, but take the risk of quitting my job in California, leaving a very safe life to try this in Europe, the Irish citizenship played a part, because not just skipping lines, it comes with it, but the ability to work freely in Europe as an EU citizen. And so I've seen, not just at the time, but I've seen since, just random kind of openings for arbitration positions in Europe. And one part will be that they're looking for an EU citizen. When I got this position in Spain, it did not specifically say that, but I have to imagine that that's something they were looking for. It just makes things much easier. I don't need a visa. I don't need to jump through any immigration hoops. I'm here just as a Spaniard would be here. And so I'm quite positive that if I had not, I guess if my brother had not figured out the rules of Irish citizenship and given that to me as a gift, I don't think I would have been willing to try this. I still would have obviously been tempted, but I think that little extra hoop would have been perhaps a little too much. And so knowing that I would be able to jump around Europe looking for jobs, ideally in Spain, as an EU citizen, just as everyone else, it was quite a benefit, and it played out quite well.
Patrick, somebody listening to this interview might very well conclude that you're one of the most fortunate or lucky people in the world, not only to have this dual citizenship, but then not speaking a word of Spanish, you get a job with a Spanish law firm. Uh, you said that they were looking for a native English speaker, but what's that all about?
Yeah, so first I'll just tell a little story because it kind of played off this. So when I went to Queen Mary originally and told people my plan, obviously everyone thought it was a little ridiculous. So I didn't know anyone at this time within the community, and a friend of a friend set me up for a coffee with an associate in the international arbitration community in London, a very accomplished one at this point, to just kind of talk about the industry. And so we sat down. I again told him my background and my goals. Said, "Oh, Madrid, huh? Madrid." He goes, "Well, as you know, Madrid's not London, not Paris, not Geneva. It's not one of the necessarily biggest hubs for arbitration." So yeah, I know. He goes, "But I assume you're at least fluent in Spanish." It's like, "Oh no, I don't speak a word." So okay, maybe you should focus on London or maybe Paris, but London definitely seems more realistic. I thought, you know what, that's fair. And so I did have trouble, finding not just openings, but even getting people to contact me within Spain. And so I had kind of given up to a certain extent. And I had secured positions in London and Paris that would have been perfectly fine to start this path. And who knows what would have happened, but Spain was still my goal. And then I said, one day we got an email, and it was actually, I didn't even see it. It was a friend of mine from the program texted me and said, "So I assume you're going to apply for this job." So what do you mean? And boom, there it was. Again, native English speaker, no Spanish necessary. And so one reason because of that, and it kind of plays into the start of my time here at Cremades Asociados, is at the time, Bernardo Cremades Sr., who's been a prominent arbitrator for decades now, has a good amount of English work. And we also have English work here as counsel. And granted, everyone in this firm speaks English. There is a difference between speaking English as for some people here, third or fourth language. But there's a difference between that and kind of the native aspect to it. At least as a native English speaker, I would hope that I have some little advantage. And so they were looking for, because they had enough work for just that little extra touch as a native English speaker for the Spanish work they had, both on the arbitrator side with Bernardo Cremades Sr. and on the counsel side for some of the larger English cases we had. And so obviously I've learned some Spanish in the 6 years since, but at the time they really had such an English need with their cases for that little extra bit that no Spanish was necessary. It worked out perfectly.
Well, that's a nice segue into inviting you to share with us a little bit about the nature of your practice and how that has evolved over the years. How long have you been in Madrid now?
I've been here now a little over 6 years, which saying out loud seems crazy to me. It feels like I just got here. The time has flown by, but it's been great. But yeah, I arrived August of 2016.
So my question is, how has your practice developed and what's the general nature of what you find yourself doing now?
Yeah, so early on, it was actually quite nice because obviously a big thing in the US and elsewhere is to clerk, after law school. And so I almost felt like I kind of got an arbitration clerkship when I first moved here. Because again, Bernardo Cremades Sr. has been a prominent arbitrator for a number of years and has some of extremely complex and large cases and has for quite a while. And so at first I did have counsel work, but I worked with him a good amount in his capacity as arbitrator. And had a lot of conversations with him about cases, got to take part in deliberations with a lot of other of the top names in the field. And so it was a nice exposure right off the bat to just, again, large cases, see how they're argued. What I've really taken away is seeing how deliberations go. It reminded me of doing jury trials in the US and then getting to speak to the jury afterwards and kind of getting an idea of what goes on behind the scenes. Because when you're an advocate, you have these ideas of, oh no, this is clearly the most important, this is what's going to matter. And so I would see some of these cases and then be part of the deliberations. And sometimes it would be how I expect it to go along. Sometimes I'd be caught off guard quite a bit by what certain arbitrators focused on. And within that, it opened up my eyes sometimes to just how the cultural differences work when it comes to arbitrators and their kind of their legal background. On issues such as, for example, just good faith would be, I think, an obvious one to me. As someone who came from California, common law litigator, if I'm arguing good faith, I'm probably not too confident on that issue, and it's probably a bit of a stretch. Whereas in continental Europe and Latin America, it really has teeth to it. And you can see in deliberation sometimes on some large cases that this concept of good faith can really sometimes override what would appear to be fairly expressed contractual provisions. And so it opened up my eyes to kind of these different ideas. And so at the same time as that, there was plenty of counsel work, both contractual or commercial and investment arbitration, and luckily some sport arbitration, since that's an interest of mine. And so it was kind of doing this, like I said, almost clerkship of secretary work with Bernard Sr. while doing my counsel work. And so recently, that the arbitrator side, at least assisting Bernard Sr. has ended, and I focus primarily on the counsel work now. But it was a great way to start my first few years.
Well, you've now transitioned from a common law practice experience to a civil law country. Tell me a little bit about that move and how successful you've been in making that adjustment.
Yeah, I'm not gonna lie, it caught me off guard, but I mean, I will say this even started at Queen Mary. Again, just hearing kind of different perspectives on what matters, what doesn't, what preferences people have of certain things. For example, I remember at Queen Mary, first hearing that, you know, in some jurisdictions, some civil law countries, they're really not fond of aggressive cross-examinations. So of course, as a litigator from California, I thought, what? Like, this is, you know, not overly aggressive, obnoxious, but they really don't even like the kind of cross-examination that seems intended to, you know, catch people in lies and point out flaws. I thought I can't even fathom this. And so then I've taken part in some arbitrations, and then I've talked with civil law attorneys afterwards. And what I thought was a brilliant cross-examination, I'll hear negative comments of, oh, I just don't think that's effective at all. I don't see why they would take that tone or take that approach. I think they're wasting their time. And it blew my mind. And again, on certain issues, the good faith is one that just comes to my mind, because I remember there's a particular case where there was just this disagreement in my mind as a common law trained litigator. I saw contractual provisions that clearly to me had a certain meaning, and that's that. And yet there was an overwhelming feeling from the continental Europe side of no, this, I understand what you're saying. I understand that's the American perspective, but no, we actually think this way, and you know, this is what matters more. And so it's been great that the transition to international arbitration has been in an office in a country where they have such different views on different aspects of law or hearings, or you know, every aspect of the arbitration itself, because it has meant that I'm just immersed in a view very different than how I was trained. And so I think it made it easier for me to open up my mind to different ways that people may think, different priorities they may have, which as an advocate, understanding that, and understanding especially if those differences are seen on the tribunal, the panel, I think that's quite advantageous. And so it took a little while for me to let go of those rules that were just ingrained in me in my early years, but I'd like to think that it has happened at this point.
I heard you say that sports arbitration is part of the experience that you had so far, and a specific subset of the international arbitration practice that you want to continue developing. I know you were involved in the Neymar litigation, which has gotten a lot of attention here among at least we would say soccer fans.
Yeah.
But tell us a little bit about your experiences in sports arbitration, and maybe to the extent that you can share anything of the Neymar case that might be of interest to our listeners.
Yeah, so I guess it started just as a child. I am just a sports fan myself, away from any aspect of law. I'm a diehard sports fan. Having my dad born in San Francisco, born and raised in San Francisco, I was raised as a Giants, Niners, Warriors fan. I'm a Bay Area guy, but I've been a diehard sports fan all my life. And so I've always realized as a lawyer that, all right, it's not necessarily the case that if you practice related to something that is of personal interest, it's necessarily going to mean that, you know, it's as fun as watching the games or something along those lines. But I have found in my experience that if I am a little more interested in the actual substance of a given case, it just adds a little something to it. There's a little more intellectual curiosity that comes with it, so I enjoy it. So at Queen Mary, sport arbitration was not really part of the curriculum. It really is its own little world, as I'm sure you know, in the arbitration community. And so we focus primarily on just general commercial arbitration and investment arbitration. I would say the two areas that there were focused were construction and energy for obvious reasons. I mean, there's a vast amount of cases that fall under those two umbrellas. Yet when it came time for the master's thesis, we got to choose our own topic. And so I wanted to study football or soccer disputes at the Court of Arbitration for Sport. And I guess similar with my decision to quit my job and try to move to Spain without speaking Spanish, wanting to write a master's thesis on sport arbitration when that was not part of the curriculum whatsoever, raised some eyebrows. And some of my classmates again, like, what are you thinking? We didn't even study this. I said, yeah, I know, but we studied arbitration, obviously, and this is something that interests me. And if I'm going to spend several hours writing, a long thesis and studying cases, I want it to be in soccer. So I wrote my thesis in that, thinking, something may come of it, maybe not. At that point, I was still focused on hopefully just finding a job, period. And so then, as if I wasn't lucky enough to find a job in Spain that didn't require a word of Spanish with a very successful arbitration team, day one, I get to my office and I have a talk with one of the partners, and he said, hey, the Neymar file's on your desk. We want you to already start reading this, and we're getting ready to file something before FIFA, and we expect this to go to the Court of Arbitration for Sport. And we want you to be a big part of this case. And I thought, oh my goodness, this just keeps getting better and better. And so that case, unfortunately, the case did not go as planned as far as a result. And oddly enough, there was a criminal trial in Spain that just ended, I think, last week, if not the week before, that all stemmed from this original dispute. And the prosecutors, after hearing witnesses, decided to dismiss the entire thing. So in the end, because we represented the Brazilian club Santos, which was where Neymar originally came from, and we were against Neymar in Barcelona. So unfortunately, we didn't achieve the success we were hoping for in that case, but it was truly fascinating to immediately get to start, not just with the Court of Arbitration for Sport, but also FIFA in a dispute that I was aware of before I even stepped foot in Spain. I was quite aware of it. And since then, I've gotten to work in counsel side and arbitrator side on a few sport disputes. The practice is still getting going, and it's definitely something I want to expand in the years coming.
I also was interested to learn that you've been involved in the celebrated case involving the Nazi theft of artwork from the Casa family. That's gotten a lot of press here in the United States. Maybe you could share some anecdotes from that particular project.
Yeah, and this is one that's been ongoing for quite a long time now. I haven't been on since the beginning, since I think this truly started about 17 years ago. But I've been on it for a number of years now, and we've filed amicus briefs in the District Court, the Ninth Circuit multiple times, and the Supreme Court multiple times. And I've been lucky enough where the courts have cited our briefs quite a few times, because oddly enough, the way the original kind of run through, the courts determined that Spanish law was actually the applicable law. And the dispute's in California. For those who don't know the dispute, this involves a Nazi looted painting that's hanging in a museum in Madrid. And it's unquestionable that the heirs live in California. So this was brought in California. The Madrid museum, the Thieves Museum, has admitted it was stolen. There's no doubt about this. The issue at hand was just whether or not they have had it for a long enough time to acquire good title over it. So the original issue was the original choice of law analysis decided it was Spanish law that would be applicable. And so the lawyers in the case and the judge obviously were US lawyers and a US judge. And so we were brought in to kind of be your Spanish law experts. And so we filed a number of briefs based on Spanish law. And of course, this was my first time filing a brief in the US Supreme Court. And if you had told me that my first time filing a brief in the US Supreme Court would be as an expert in Spanish law, I would not have agreed with the probability of that. But we did so. We're successful at that stage, the issue was went back to choice of law, because unfortunately the US courts, despite our attempts to assist them, in my opinion, butchered the application of Spanish law. And so actually it has now gone back to the Ninth Circuit with a brand new choice of law analysis. And so now we're back to disputing whether or not California law or Spanish law applies. And really, in the end, whatever, if the Ninth Circuit decides that California law applies, it's undoubtedly the case, and all sides have admitted that the painting will be found to belong to the heirs in California. But if Spanish law applies, unfortunately, the U.S. courts have, in my opinion, again, misinterpreted Spanish law and determined that under Spanish law, it belongs here. It's been a big deal, big news here for a number of years. A lot of us find it quite frustrating that the museum has taken this position. As I'm sure you're aware, and a lot of listeners may be aware, it's not uncommon for a museum to discover that they have Nazi looted art, and a lot of museums have taken it upon themselves to return art once they discover this, instead of fight to keep it. So we find the whole position unfortunate, but from a legal perspective, being an American in Spain, filing briefs on Spanish law as an expert in Spanish law in U.S. courts has been a very interesting experience. And I never thought I'd be quoted by, the Spanish Los Angeles Times with quotes in Spanish. It's been a unique experience.
I know that most of your practice today involves ICSID litigation and disputes, and I'd be certainly interested in knowing a little bit more about the experiences you've had handling that particular type of international arbitration.
Yeah, we specialize here in kind of large investment treaty cases. We do a lot of work in Latin America, and even then, there's been some. I mean, the investment, kind of going back, just to again highlight how lucky I feel I was. I remember in Queen Mary when we were discussing what classes to take, one of the courses was investment treaty arbitration, and a classmate of mine who had been an international arbitration practitioner for a number of years told me, look, maybe you don't even want to take this class, because I'm telling you, it's interesting, but there's only a handful of people on earth who ever get to actually practice this. So, maybe it'd be better studying something else. And boom, I land here and all of a sudden have ICSID cases nonstop. And so we have quite a few large cases in Latin America on a wide variety of industries, whether it's pharmaceuticals or banking. And again, from someone with a background in California where I thought international anything was just kind of nonsense and just focused on my local litigation, writing briefs based on international law and international principles and getting into public and private international law and treaties, it was not something I ever thought I would do. And then even aside from the investment cases, we've had some interesting commercial cases, which perhaps got the size of what you expect some investment cases, including a recent $15 billion win. But I don't know if we'll talk about that, but that was a commercial dispute. But yeah, the ICSID disputes, I feel fortunate, and I think it provides the unique opportunity to really be part of drafting these large submissions that are so encompassing of ideas and principles and interesting geopolitical facts that I never thought that I would touch as just kind of a domestic litigator back home.
Well, I can't close out without at least asking you about this big win that you had in a piece of commercial arbitration. That sounds fascinating.
Yeah, so this case, I actually just went to a conference in Dublin with a partner of mine, and we spoke just about this case for an hour. I'm not going to do that now, but it's a very interesting case. So it involved a lease from 1878 involving land in North Borneo, now present-day Sabah in what is modern-day Malaysia. And it basically dealt with the use and exploitation of land there. At the time, the land was just used to sell, I think it was bird nests and seed pearls, something along those lines. And so the deal originally was between the Sultan of Sulu and a couple individuals who, for the sake of the summary, don't really matter. And the use of the land was the use and exploitation of land agreement was for $5,000 a year, which eventually was up to $5,300 a year. So there are some successive parties. Eventually, the Sultan ceased being the leader, deeded his rights to his nieces and nephews, who were then the descendants of them were our clients. The other side, it went from these individuals to the North Borneo Trading Company, to the British government, to modern day Malaysia. So this deal continues on, but lo and behold, in the latter half of the 20th century, it's found out that the land that initially was for bird nests and seed pearls is quite rich with hydrocarbons and palm oil. And so by the time arbitration came about, it was found out that the revenue from that land was about 3 million times what the rent was being paid for the lease. And so it got quite complex because the arbitration agreement was not only, the agreement was written in a Malay dialect, an Arabic script with only a handful of people being able to translate. There were issues because the arbitration agreement called for disputes to be decided by, I think it was Her Majesty's Consul General in Brunei, which is something that no longer exists. So we managed to get this arbitration started in Spain because at the time of the lease, that territory in North Borneo was under the Spanish Empire. So we ended up getting the arbitration kicked off in Spain. During that time, Malaysia did not participate, but there were a lot of attempts to prevent some obstacles. There's an anti-suit injunction issued by Malaysia, which we convinced the arbitrator to continue despite that. And so eventually, there were a couple different theories we had, but during the arbitration, the Attorney General of Malaysia, while not participating in the arbitration and not acknowledging that it was legitimate arbitration, sent us a letter admitting that they breached the lease by ceasing payment as of 2013. The $5,300 a year they stopped paying as of 2013. We ended up using that letter, as you can imagine, as proof of the breach. And so in the end, the award found that there was a breach. Our argument was that because of the breach, we would normally be due restitution of the land, but considering that would start a war, that was not realistic. And so therefore, we should get a certain portion of the profits for a certain period of time, which was contemplated to be, or calculated to be about $15 billion. Interestingly enough, while we were waiting for the award to be submitted after the hearing, the Spanish court actually ended up annulling the decision to appoint the arbitrator in the first place. And so at that time, the argument was obviously on one side that we no longer had any case going because the arbitrator appointment had been annulled. But before that, there had been an award on jurisdiction issued by the arbitrator, which had not been specifically annulled. And under Spanish law, just because the arbitrator appointment had been annulled does not automatically wipe out the jurisdictional award that we had. So we went ahead and took that to France, got it recognized in France, and then successfully argued to the arbitrator that he should just move the seat to France instead of Spain, because the Spanish courts were now unnecessarily interfering with legitimate arbitration. And so ultimately, even though it was a Madrid seat to start, this case got moved to France and the award was issued with a French seat for the 15 billion. And since then, we've been able to enforce it to a certain extent. We had a couple $1 billion of assets seized in Luxembourg from a subsidiary of a Malaysian oil company, and we're working on enforcement in the Netherlands as well.
Just another day in the life of a kid from Fresno, California.
Yeah, exactly. And another aspect, it just interesting one of that is during it, the Malaysian courts then got quite upset that we ignored the anti-suit injunction, and at one point basically issued a directive that indicated that we could possibly be subject to execution if we were to enter Malaysia. So needless to say, that has been crossed off my vacation list for the time being. Unfortunately, I did not make it there before this happened. But yeah, it got quite interesting. They're trying to pursue criminal charges against the arbitrator now. It was yeah, exactly what I expected when I first decided to move back to Fresno to just be cozy in my hometown and start my practice.
Patrick, this has been a delightful way to spend a few minutes with a most interesting young man with a most fruitful career yet ahead of you. Thank you for taking the time to share some of your experiences to help our listeners understand the travels that you have made and to reach where you are today. Best of wishes to you for this upcoming holiday season. And we thank you again for taking the time to share your thoughts.
Yeah, thank you. Thank you very much. It's been fun. It's been a pleasure. Appreciate it.